Welcome to U.S. Immigration TV. In this video, I will discuss the effect of a fixed marriage on your children. And I have a letter here that really illustrates what the problem or situation here is. Let me just read it. Dear Attorney Gurfinkel, my father married a U.S. citizen who petitioned both of us for green cards. We were able to get our 2-year conditional green cards, but when we filed to remove the conditions, tragedy struck. At the interview, my father and his citizen wife got nervous and their answers didn't match. Well, she eventually agreed with the officer to withdraw our petitions, and she even signed a confession that her marriage to my father was fixed. So I know my father is now subject to a lifetime ban and no petition can ever be approved for him again. But I'm now married to a U.S. citizen. Am I also subject to that lifetime ban, or is there hope for me despite my father's fixed marriage? Very truly yours, DC. All right, so here's my answer to DC and others of you out there who have a similar situation. Parent caught in a fixed marriage. Okay, well, U.S. immigration law, and in particular, Section 204C, provides that, and I quote, no petition shall be approved if an alien previously sought a green card by reason of a marriage determined by the USCIS to have been entered into for the purposes of evading the immigration laws, or the USCIS has determined that the alien has attempted or conspired to enter into a marriage for the purpose of evading the immigration laws. In other words, if a person is ever caught in a fixed marriage, no future petition can ever be approved for them, whether it is through a new marriage that is truly for love, or even if they now have a U.S. citizen child who is over 21 years of age, or they have an employer. I mean, I have many people who come to me and say, I was caught in a fixed marriage 10 years ago, but this marriage is for love, or my kid is 21. Can they petition me? No, it is a lifetime ban on a fixed marriage. So it would appear in this particular situation, your father is subject to Section 204C unless he can demonstrate that the marriage was not fixed. And the definition of that is, at the time of the wedding, the couple intended to have a life together. As long as on their wedding day they intended to have a life together, then it perhaps may not be fixed. But that's a different topic, different issue about how to get out of fixed marriages. Let's talk about the children. There could be hope for you as the U.S. citizen's stepchild. Cases have held that stepchildren of the U.S. citizen petitioner are not subject to the lifetime ban under Section 204C. Therefore, it could be possible for you as the stepchild to be petitioned and for that petition to be approved. Now, if you are married to a U.S. citizen, it could be possible for that U.S. citizen to petition you without being subject to the lifetime ban under Section 204C, as your father may be. However, I would strongly recommend that before filing anything, you first consult with an immigration attorney who could evaluate your case and make sure you are eligible for the benefits. And, for example, you have not been placed in deportation, or if there are other potential issues with your case. But the bottom line is that if a parent gets caught in a fixed marriage, their children, who are the petitioner's stepchildren, are not subject to the lifetime ban of Section 204C. I hope you have found this video helpful. Maybe if not for yourself, maybe you know somebody who was caught in a fixed marriage and they had children. It would be nice for them to know that there could be pagasa for their children. I will continue posting videos on this channel, which I hope you will find informative, and therefore make sure to like, share, and subscribe to this channel, especially subscribe. I'm Michael Gurfinkel, and thank you again for watching U.S. Immigration TV.